Hello friends, my name is Raza Masood. Today we'll discuss about a topic privity. Friend, this is a very important topic with respect to contracting or business negotiation or project management. So friend, we will see this topic with reference to project management or business negotiations or contracting. Mainly friend, this is a part of contract. So friend, if you are studying project management or business administration, so you will see this topic in the exam, and few questions will definitely be there which are directly related to this topic privity. Also friend, if you are a professional person, either you are a project manager or you are a business manager, so again this is a topic which you must know that how to deal with it and what is its importance to understand with respect to contracting. Okay friend, so first of all I would request to please subscribe to my channel and click on the bell option as well so that my new videos can reach to you. So let's start. Privity. Friend, privity, this is a topic which is related to contract. Okay, whenever we talk about contract, so this topic is directly pertains to contract. Okay, so first of all we have to understand what is a contract, friend. Afterwards we can discuss about the privity with some example. Friend, contract is a legal document, is an agreement between two parties based on some terms and conditions. For example, you want to purchase a car and you went on a showroom of car and you decide and like some car to just purchase, and after some negotiations on car prices, so you decide to purchase it. The car vendor or the car seller, he provides you a contract and agreement that you are purchasing this car, and on this terms and condition, this will be the price. So friend, basically, and you signed that document, you agreed that document, and you buy it the car. So friend, basically what is all these things? This is an agreement, this is a type of contract. Basically, another type of contract is that whenever you want to rent a house, so any person who want to take your house as a rent pay, and with some terms and conditions, you make a contract with him. Remember friend, one thing, that contract is a legal document. A legal document means that it can be challenged, it can be put in a court as well. So first of all we have to understand the concept of contract. Basically, what is a contract? Contract is a agreement between two parties based on some terms and condition. This is called as the concept of contract. Now privity, what is privity then? Friend, privity is a doctrine of contract law that says contracts are only bindings on the parties to a contract, and no third party can enforce the contract or be used under it. Lack of privity exists when parties have no contractual obligations to one another, thereby eliminating obligations, liabilities, and access to certain rights. Basically, friend, privity tells you, as per the contract definition, this tells you that only the parties which involved in the contract are obliged, or they are enforced to follow the rules and the terms and conditions which are defined in the contract, and no other party other than the two parties of contractual can force you to do something. Okay, so just first of all try to observe this definition. Privity tells you this is a contract. As per the contract, it tells you that only the parties which are involved in the contract, they are liable, they are enforced to follow the rules which are defined in the contract, and no other party which is not defined in the contract are not liable or not enforced to follow the rules. Okay, just take it like that. Now friend, what are the key points here in the privity? Friend, the key point is that in the contract law, privity is a doctrine that impose rights and obligations to parties of a contract and restrict non-contractual parties from enforcing the contract. Lack of privity states that there is no contract between the parties, thereby not requiring them to perform certain duties and not entitling entitling them to certain rights. The strict liability and implied warranty doctrines allow third parties to sue manufacturers for faulty goods even though they are not parties to the original contract. Okay, now friend, I just want to give you an example just to try to explain the concept of privity here. I know that this is maybe difficult for you to understand just from the definition, so let me give you an example to understand the concept of privity. Friend, just take an example that April signs a contract to sublease a Manhattan one bedroom condo from her friend Jessica, who leases the unit from its owner. But before entering into a contract with April, Jessica obtained written permission from her landlord. This permission does not absolve Jessica from her duties as Bird's tenant, as privity still exists between them. See, friend, here. Uh, friend, see. You are, for example, there is one person A, person B, and person C. A A is the owner of the house, okay, owner of the flat. B has a contract with the person A. So from the permission of A, B leased the flat to another his friend C. Okay, just try to understand the concept of privity here. See, there are three person A, B, C. Okay, person A is the owner of flat. Person B is a person who is residing in the flat. However, he leased the flat with the permission of A to person C. Now just take the example, after 6 months into the 1 year lease, April, the person C basically, threw a large party and her guest caused $10,000 in damage to the unit. Bird, person A, sent the bill for damages to Jessica, person B, and in response Jessica demanded payment from April. Unfortunately, April vacated the apartment and avoided Jessica's attempts to recover for damage and unpaid rent. See what happened. The Bert is a person who is the owner of the flat. Jessica was has a contract with Bert, and the April is she threw a party in the flat and her guest damaged the flat of around $10,000. Now the owner of the flat threw a bill of damage of $10,000 to Jessica. Now try to understand the concept here. Jessica is not responsible for all the damage. April was the responsible for the damages. And the contract between, what is the contractual obligations here? The owner of a flat has a contract with Jessica, but Jessica has not damaged the flat. All the damages were done by April. But now see here, since Jessica is the original tenant named on the lease, she is culpable for any damages to the unit and is responsible for rents due and performing all duties as specified in the original lease. April has no privity with Bird. Therefore, Jessica must pay Bird for the damage or he can take legal action against it. However, she is not defenseless as she can sue April since April has a privity with the Jessica. As the Jessica has the privity with the April. So now what happened that the person of honor, the owner of the flat basically give a damage bill to Jessica, and then Jessica will sue, or Jessica has a privity agreement privity with the April. So Jessica will give this bill to April. April is responsible to give the payment to Jessica, and then Jessica will give it to the owner of the flat. So now see friend here, due to the privity between Jessica and April, Jessica becomes safe. If there is no privity between Jessica and the April, so Jessica will definitely be in a big trouble, because see, Jessica, as per the original lease, Jessica is responsible to pay all the bills whatever happened in the flat. Now Jessica as the privity with the April, so Jessica will give that bill of 10,000 to April, and April is responsible and liable as per the court, as per the legal document. He is responsible to pay all the bill of $10,000 to Jessica, and then Jessica pay it to the bird or owner of the flat. So due to the privity, all these things can be resolved properly. So friend, thank you, thanks a lot for your time, and that's all from my side. I hope you like this video. If you like, please share it with your friends and colleagues, and thanks a lot for your time.